Hello and welcome to the Future of the Cole Memo and Attorney General Sessions' views on marijuana enforcement. Our webinar today is with Saul Ewing, Arnstein & Lear in partnership with Infocast Events. Today I have with me Jonathan Haven, co-chair of Cannabis Law at Saul Ewing, Arnstein & Lear. Jonathan's unique perspective on cannabis regulation is informed by his congressional, federal agency, and national and international law firm experience. And before we get started, today's webinar is a preview of what you can experience at InFocus Canada East Compliance Summit 2018, which is in January in Orlando, Florida. And at our summit, you can discover the latest intel from key cannabis regulators and policymakers as the industry continues to grow with the rapid expansion of marijuana legalization. And you can check out our featured speakers here on this slide. For more information or to register, please go to infocasinc.com/event, and you can look for Canada East Compliance Summit or type in the full URL here on the bottom. Again, that's infocasinc.com/event for Canada East Compliance Summit. And now, just to get through a little bit of our housekeeping, if you guys have any questions during this webinar, please type your questions in the Q&A box in the lower right-hand corner of your screen, and we will answer your questions if time permits. Thank you so much, and now I'd like to welcome Jonathan.
Thanks so much, Catherine, and I appreciate everyone attending today. Certainly a timely topic. For those of you who have been following DOJ, Department of Justice developments in this space, you are well aware of the fact that the Attorney General just this week and some of his deputies have made some statements that have created some confusion and uncertainty in the cannabis space. So I think this is always a timely topic, but particularly timely given the potential government shutdown later this week and also the possible expiration of the Rohrabacher-Blumenauer Amendment, which I will talk about a little bit later in my presentation. Don't want to get ahead of myself. I do want to provide some overview information, especially for those of you who are new to the space who are thinking about getting into the space. So what's the regulatory status of cannabis? And here are the facts. More than 50% of the states in the United States have medical cannabis laws in their books, and then 8 states with medical cannabis also have recreational cannabis laws on their books. I think these trends will continue. You have seen in the most recent elections that marijuana was pretty big at the ballot box. I'm going to be talking about that a little bit. But it's important to remember that even in states that have authorized cannabis activities, and I say authorized on purpose, not legalized, marijuana is still illegal under federal law. And that is because it's a Schedule I drug under the Controlled Substances Act. And so I think a lot of times when you hear people talk about medical marijuana laws in states, they say, well, the states have legalized marijuana for medical use and or for recreational use. I don't want to be a party pooper, but I do want to tell you that it's incorrect to say that marijuana is legalized anywhere, because until it is descheduled by the DEA, the Drug Enforcement Administration, it is still federally illegal. And so I'm more careful with the language I use when talking to people in the space, when talking to clients about the fact that even if a state tells you you can grow, process, dispense, consume marijuana, it's still federally illegal. So I just want to, in the back of your minds, keep that lens as we talk about the developments in this space. If we could go to the next slide, please. So the title of this memo is the future, title of this webinar is the future of the Cole Memo and Attorney General Jeff Sessions' views on marijuana enforcement. So what is the Cole Memo? So this was a memo that was issued in 2009 by Deputy Attorney General James Cole. And what it says is there's 2 premises. The first is that state laws don't change marijuana's legal status under federal law, which is precisely what I just said. States can do whatever they want within reason to allow growing, processing, dispensing of marijuana, but it doesn't change the fact that it's still a Schedule I drug under the Controlled Substances Act. The second part, and I think probably more important or more interesting to people on this call, and to companies in this space, is that the Cole Memo directs U.S. attorneys to utilize resources prudently and to use discretion before prosecuting those who are involved in the state marijuana programs, whether those are on the cannabis side, the growers, processors, dispensers, or on the patient side, the people who are getting the medical products or the adult use recreational products if the state has those laws. So this was a pretty significant shift the Cole Memo was in drug enforcement, and after it was issued, prosecutions for marijuana offenses declined pretty significantly in states that had marijuana laws on their books. If we could go to the next slide, please. So Attorney General Jeff Sessions, a little bit of background on him, was a senator from Alabama for a few terms, was obviously nominated by the president to be the Attorney General. And if you followed Jeff Sessions' actions, quotes, predictions, admonitions in this space, you're well aware of the fact that he's no fan of marijuana for either medical or recreational use, especially not recreational use. So let's drill down deeper, because just knowing that Sessions is not a fan of marijuana doesn't really help any of us. And I as an attorney and an advisor to people in this space, I don't base my advice on speculation. I base that advice and guidance on hard facts. So here are the facts. So Jeff Sessions has acknowledged the existence of the Cole Memo, but it's also important to know that earlier this year, he issued a memo of his own. And what that memo does is it directs federal prosecutors to pursue the most serious, readily provable drug offenses. And under his program, or under his program at the DOJ, it rolls back policies under President Obama's administration. And what it says is that if prosecutors, if U.S. attorneys want to pursue anything less than the most serious charges for drug offenses, they need to obtain multiple layers of approval. So as you can tell, it makes it pretty difficult for people to do their jobs and to pursue anything less than the most serious offenses, because if you need these multiple layers of approvals, and presumably Sessions has told the higher-ups not to grant them, it's going to be difficult to do that. I just want to pause for a moment. You'll see links throughout this presentation, and I believe a copy of the presentation will be available to you later if it's not already. I want you to have these links for a couple of reasons. One, so you can see the resources that I consult and that I'm looking at on a day-to-day basis, but also so you can have access and you can back up what I'm saying. Some of these issues are not cut and dry. Some people will disagree with my interpretations of these policies, so draw your own conclusions. I'm simply offering my, what I think about these policies and these developments. Next slide, please. So a little bit more on Jeff Sessions. So at a pretty recent House Judiciary Committee hearing, what Jeff Sessions said is, and this was music, I think, to the cannabis industry's ears, is that his policy, DOJ's policy under his tenure, is really the same as it was under the Obama administration, under Attorneys General Holder and Lynch. And that means that federal law still makes it illegal to be engaged in growing, processing, dispensing, or consuming of cannabis. And so I think that was interesting. It was one of the first times I think I heard him acknowledge directly that his policy is the same as the previous administration's. Again, I think what we can say is, okay, the Cole Memo is still valid. DOJ still has some sort of respect for it. A federal court, for what it's worth, the Ninth Circuit said last year that Rohrabacher-Blumenauer, the amendment I talked about earlier, which protects some activities at the state level, and I'll talk more about what those are later, what it does is this court decision says that it is prohibited to prosecute patients and providers who are acting within the confines of these state marijuana programs. Next slide, please. So again, these are some quotes, and I want to stop here and say I hope that you view this presentation as being apolitical, certainly not trying to get political. I'm again reporting what I deem to be the undisputed facts about the cannabis space, but I am reading you these quotes to show you the healthy degree of skepticism that Jeff Sessions, our current Attorney General, and I would say some of his deputies at DOJ have for marijuana. So he said good people don't smoke marijuana. He's dubious about the benefits of the drug. He's surprised that Americans are not overwhelmingly embracing his anti-cannabis stance, and he's willing to rewrite the Cole Memo. I think the last point is probably the most significant one there. The Cole Memo is not law, it's policy, and so I think he can do whatever he wants with it. Interestingly, some actions that he's taken since being in office, he's asked congressional leaders not to renew this Rohrabacher-Blumenauer protection that I've talked about. The House and Senate both rejected his request, so I have a little bit more here about the sources that I've consulted for this. And he's also issued a memo recently that prohibits DOJ from the Department of Justice from issuing guidance documents that have the effect of adopting new requirements or amending the law. So this is interesting because, and this was fairly recently, it was in the past couple of weeks, but a commentator who publishes something called the Marijuana Moment, which is a newsletter I follow and get each day, Tom Angel, has interpreted this memo, and I think correctly, to say that even though Sessions here didn't say that he was talking about the Cole Memo, I think what he is doing is establishing a record and saying, under my tenure as the Attorney General, we are going to be very careful about these memos that aren't enforceable, and they're not going to dictate necessarily how we interpret law and regulation. Next slide, please. So some more actions that Sessions has taken, and I think these are particularly interesting when you see the states that he's taken actions in. So he sent letters to the governors of Colorado, Oregon, and Washington State about those states' cannabis programs. And the reason I think it's interesting is because those states, I think, are looked to as leaders in the cannabis space. They've had programs for a while. The programs are pretty robust, both on the business side and on the patient side, or on the adult use side, as is the case. So I think these are interesting that he's not going after what I would consider to be the small-time players. And you know, he sent letters to them and hinted at potential DOJ crackdowns. And what he's doing here is he's interpreting pretty strictly the Cole Memo. And what I mean by that is, and we're going to talk a little bit later about this, there are certain enforcement priorities in the Cole Memo. And yes, generally speaking, if you are growing, processing, dispensing, or consuming cannabis in line with your state's laws, I don't see DOJ as interfering with that. What I see an interference with is interfering with states who don't have good control on other behaviors that come along with having authorized cannabis activities. I'll talk a little bit more about what those are, but again, I think Sessions is trying to establish a record and go after things that he believes are in his and DOJ's power. Again, I'll give some more details. So John Hudak, who's a drug policy expert and senior fellow with the Brookings Institution, pretty well-respected voice in this space, has said along the lines of what I've just said. What's interesting here, again, is that Sessions' accusations of these states are not, are not complying with the Cole Memo, perhaps suggesting he's okay with the Cole Memo. But again, it's the other ancillary activities that are going on. Next slide, please. So I thought the following quote that Sessions made, again, during recent congressional testimony was a little bit of a head-scratcher, which is that, in his view, it would be healthy to have more competition among medical marijuana growers for research. There was a discussion of how many suppliers need to be out there. Currently, there's one. It's the NIDA farm in Mississippi. And so, for good research to happen, you need good supply, and I don't think anybody in the space would dispute the fact that there's been a chokehold on research supply. And so this question from a member of Congress, I'm not sure who it was, I'm sure it's in this article that I have linked here, but discussion of increasing the supply for research cannabis. And so I thought it was interesting for someone who's so opposed to cannabis that they thought it would be healthy to have more competition for research facilities. Another thing that I thought was interesting is that Sessions asked his own Department of Justice deputies task force to review the Cole Memo and recommend changes, and they gave him absolutely no ammunition. So that happened earlier this year. Next slide, please. So here are some takeaways and considerations. I've given you some quotes. I've given you some high-level philosophies and talking points about Sessions, but here's really where the rubber meets the road. Again, Sessions has said that the Cole Memo is, quote, truly valuable in evaluating cases. So you would think someone who's not in favor of marijuana, why are they in favor of this memo, which was seen as making it easier for states and people within those states to be involved in the marijuana space? And I think the reason he said it's truly valuable is he's really using and pulling apart the Cole Memo for his benefit and what he thinks is the country's benefit. And I talked about these enforcement priorities in the Cole Memo, and essentially what these enforcement priorities say is DOJ should not go after people who are operating within the confines of these state programs, but DOJ can and should go after certain behaviors, certain activities that are contrary to the public health, to public safety. And so I think what Sessions has attacked or attached to in the Cole Memo are those things that he thinks give him justification and DOJ's justification to interfere, so to speak, with these state programs. And those are, among other things, preventing distribution to minors, preventing diversion of marijuana from states where it's legal to states where it's not. So think about states that border Colorado and states like Utah where it's not currently legal for any reason. Preventing drug driving and the exacerbation of other adverse public health consequences, and preventing marijuana possession or use on public property. I want to stop and pause and just have you consider for a second what each of these enforcement priorities are saying. If you're thinking to yourself, man, it would be really hard for a state to enforce on its own all of these things, and how does a state prohibit one of its citizens from going, crossing a border with medical marijuana in their car? The answer is it's pretty impossible, or close to impossible. And so I think these enforcement priorities, Attorney General Sessions sees these enforcement priorities as allowing DOJ potentially to interfere with states. Now, I don't think we've seen widespread interference, but the letters, again, to these three governors should give you an indication that Sessions, at least on paper, is not afraid to rattle these states. The other things that I'll talk about are, number one, like any cabinet appointee, Jeff Sessions serves at the pleasure of the president. He was appointed by the president, can be removed by the president. The other thing to notice is that some people would say that Sessions is distracted by the Senate's investigation into the Trump campaign's alleged contact with Russians during the election. I would say that to hang your hat on that is short-sighted, and I wouldn't put too much stock in that. And there's a Washington Post article here which pretty much says exactly that, and in more detail says that Sessions, while everyone's been focused on the Russia investigation and thinking that is he going to get fired and is he going to be able to oversee this marijuana program, the answer, I think, for the time being is it's status quo, and people should expect DOJ to continue to be active in this and many other spaces. DOJ has been drastically overhauled since Sessions came into office, and so I wouldn't expect that he's distracted. Next slide, please. So, we talked about the fact that Sessions serves at the pleasure of the president and is the president dictating DOJ's policies and other cabinet agencies' policies on marijuana. And the truth is, we don't really know that much about President Trump's views on marijuana. Again, we can speculate, but I'd rather stick to the facts and what we do know. The first, and I would say most concrete piece of evidence that we know is that, like Jeff Sessions, President Trump is reserving the right to interfere with state programs. And what I mean by that is, if you look at the omnibus bill, which is one of these mass spending bills when individual appropriations bills can't get done, which has been the case for a few years now, the president, during the last omnibus bill signing, in a signing statement, a written statement, said that, and I'm not going to read the specific section, but referring to the prohibition on Fed interference with state programs, state marijuana programs, that the Department of Justice, recognizing that the Department of Justice can't use any of these funds to prevent implementation on the state level. However, and this is a big however, I, Donald Trump, will treat this provision consistently with my constitutional responsibility to take care that the laws be faithfully executed. So what does that mean? I think it means something along the lines of what Jeff Sessions has said with the Cole Memo. We hear what the Cole Memo says. We hear what Rohrabacher-Blumenauer says, that we're not supposed to interfere and expend funds on interfering with state marijuana programs. However, if we think there's another reason to get involved, like public health, safety, diversion of minors, drug driving, all those sorts of things, then I think the president here is reserving the opportunity to get involved. And again, Tom Angel, a commentator who I follow pretty closely, and his read is basically saying that they reserve the right to do whatever they want. And I would agree with that. Next slide, please. So on the campaign trail, President Trump said something about marijuana, and I would caveat this with it was a campaign statement, and politicians on both sides of the aisle, or any political stripe or color, say lots of things on the campaign trail. So take this for what it's worth, but he did say on the campaign trail that he was in favor of medical marijuana 100%, that he was skeptical of legalizing it more broadly, and that it should be a states' rights issue. I would say that's probably still his view, but again, he's going to reserve the right to get involved if he sees a broader public health, public safety issue. The current White House Chief of Staff, John Kelly, when he was Homeland Security Secretary, said some interesting things about marijuana, and that he said it's not a factor in the drug war, which is a pretty staggering statement. I mean, when you think about the war on drugs, marijuana was a big part of the war on drugs. Might still be as far as some federal regulators are concerned. I would say as far as Jeff Sessions is concerned. But that's an interesting statement from one of the president's closest advisors right now. He said that it is, but he's also said it's a gateway drug, a little bit of a head scratcher, and that it could be grounds for deportation of undocumented immigrants. So again, I'm not putting too much stock in what he's saying because they're conflicting, and also because he's not directly, in my view, writing or enforcing federal drug policy. Next slide, please. So public opinion. Public opinion is pretty interesting because for two reasons. One, I would say any poll you look at, there's overwhelming public support for some sort of state marijuana program. More so for medical than for recreational, but the numbers for rec programs are still pretty high. And the numbers for non-federal interference are very high. So people that don't want the federal government to interfere with states that have duly enacted their own laws. So there was a Quinnipiac poll in August, 93% are in favor, and this was up 5 points from that same question last year. I'm not going to read all of these polls. You can see where I've gotten them from here. Next slide, please. So I talked about marijuana at the ballot box. Leafly is another organization that I follow pretty closely. They've got a great news feed that pretty closely follows national and state and local developments. So they did a big election recap, and I think any way you slice it, marijuana was won big at the ballot box. Again, these are quotes. I don't want to get political, but for example, the first quote about Chris Christie, who he didn't lose the election. He wasn't up for election, but he is a pretty notorious drug prohibitionist, has been advising the president on opioid issues and is leading this opioid task force. But New Jersey, in a pretty big rebuke to Chris Christie, supported the pro-legalization candidate, Phil Murphy. Detroit, passed these ordinances well above the majority at 60%. Athens, Ohio, 77%. So you can see there's pretty broad support, not only in public opinion polls, not just when someone is asked to fill out a survey, but also when they go to the ballot box. Next slide, please. So my predictions. These aren't bold, and like any predictions, they could be wrong. But here are my predictions. The first one, really not bold because the writing's already on the wall. States are going to continue to legalize cannabis, both medically and recreationally. I think states that only have med laws on the books are going to push the envelope and adopt recreational laws. With regard to the Trump administration, I think the administration is neither going to support nor hamper efforts in this space. What I mean by that is I don't think that cannabis is going to be descheduled. I don't think that the federal banking restrictions are going to be eased. And so, again, I think the challenges are going to remain for the businesses in this space throughout the Trump administration. Next slide, please. So I have 2 slides here that are just simply called Cannabis, It's Complicated. For those of you who are in the space or are attorneys who advise people in the space, you are well aware of these issues, but I just want to call attention to the fact that because marijuana is federally illegal, and a lot of these challenges are based on federal programs and regulations, it's very difficult to run a state-authorized cannabis business, even in states like Colorado, which have a robust program. Banking, very difficult. You know, despite what the Treasury Department says, if you look at the numbers of banks that say they will allow cannabis businesses to use those banks, it's very low. It's a handful per state on average. Intellectual property protection. There's some state-level protection. You may be using the Lanham Act to protect an unregistered trademark. Interestingly, the U.S. Patent and Trademark Office on one side of the house seems to be okay with it from a trademark perspective, but from a patent perspective, maybe not. Real estate, pretty difficult to get commercial lending. There are also zoning restrictions. So I'm just keying up what these challenges are. Next slide, please. Tax deductions. Again, there's been some proposals about the IRS code, the IRC, Internal Revenue Code, excuse me, and 280E and deductions. But the fact of the matter is the effective tax rate for most businesses out there can be well above 50%. And taking deductions is not a foregone conclusion. I'm not saying that you can't take deductions. What I'm saying is I think businesses are finding it very challenging to take deductions for what a legal business, a federally legal business, would be able to take deductions for. Discrimination, this is more for employers. This is more an employer issue, but you know, you've seen if an employer tries to fire someone who failed a drug test, or they refuse to hire someone who failed a drug test, but that person has a medical marijuana card in a state where it's legal, I think you're seeing there's some litigation around that, and whether it's discrimination, failure to accommodate. So there's a lot of tension between federal and state laws in this space. Drug testing I just talked about. Next slide, please. Federal legislation. So I want to leave time for questions, but I do want to spend a minute on Rohrabacher-Blumenauer. What this is it's usually an amendment, a rider to an appropriations bill or an omnibus spending bill as it's been offered for the past several years. What it does is it prohibits the Department of Justice from using federal funds to interfere with state medical marijuana laws. And so Rohrabacher-Blumenauer is a pretty significant thing for states that have programs for doctors that are prescribing or recommending medical marijuana to patients, for patients that are using it, for patients that are growing their own supply in states that allow that. So it's pretty significant, and it needs to be renewed this week. If it's not, it goes away, and if there's a federal government shutdown that is particularly exacerbated because drug enforcement agents, as again Tom Angel wrote in a recent Forbes article, drug enforcement agents generally accepted from shutdown furlough requirements, they're going to still be on the job. And if Rohrabacher-Blumenauer goes away and DEA agents are still working, I think that could be disastrous for state marijuana programs. So this is very significant. You should be paying pretty close attention, if you're not already, to the status of the bill that Blumenauer is attached to. Again, the question, is it permanent? Clearly not, based on what I just said. The omnibus bill funds the most recent bill, the one that's about to expire, funds the government through December 8th, so just a couple of days from now. And so again, for the government to be funded, for Rohrabacher-Blumenauer to extend, the bill needs to go through, and Rohrabacher-Blumenauer needs to be adopted as part of the bill. So a lot going on this week. Pay particular attention to the budget debate, to the tax debate, because there are major implications for the cannabis industry. Next slide, please. So the next couple slides are pieces of legislation, and at first I was going to handicap out for you which one of these I thought had the best chances of passage, But I will generally say, and this is an overgeneralization, but again, I want to leave questions for time for questions. Federal legislation on marijuana is very difficult. You will see massive support in the House. 66 members of Congress just sent a letter, sent a letter to leadership urging them to propose and readopt Rohrabacher-Blumenauer. There's widespread support. There's a lot of people on both the Republican and the Democratic sides of the aisle who are supporting these issues, but very difficult to get consensus, passage, presidential signature on these pieces of legislation. Some of them, I think, have more legs than others. Protection for veterans. You would think these would get passed. There's been a big push in the veterans communities about medical marijuana for post-traumatic stress disorder or PTSD, but there have been restrictions at the Department of Veterans Affairs on ability to test and treat veterans. So, some of these, you kind of wonder why they don't have more support. I think people are still skeptical of the marijuana space. They think, oh, this is just an excuse for people to get high. They don't understand the medicinal benefits. They don't understand why it's so important to have research. And so I would say these are kind of the more notable pieces of legislation that NORML, which is a advocacy group, has highlighted, but I don't necessarily see any of these moving. I think Rohrabacher-Blumenauer is the one most likely to move. But again, once you get my slide deck, you will be able to click on links to all of these. Next slide, please. So these are some state legalization efforts. I talked about New Jersey. Pennsylvania has introduced a bill, Wisconsin, Illinois, D.C. So there's also decriminalization bills. So legalization, generally what that means is adult use. So anybody over the age of 21 can purchase and use or grow and use for their own consumption. Decriminalization, lessening the penalties for possession, use, so to speak, marijuana activity. So that's the distinction there. Next slide, please. So same things here, just calling your attention to some legislation. This Florida piece of legislation is interesting. So Florida, and this is a good reason to highlight the differences between state laws. Florida has a medical marijuana program on their books, but they don't allow inhalation of marijuana. So there's no smokable, like lighting up combustion of marijuana in Florida. Some might say, well, that's silly, but that's just the way that certain states have gotten themselves comfortable and issued laws. And so, again, different states, very different laws. If you're thinking about getting involved in the industry or advising, I'm not going to give you legal advice on how to advise your own clients, but you would be very, very well served by making sure you know the distinctions between the state laws, and also that if product is crossing state lines, you are 100% in violation of federal law. I think that might be the last substantive slide, but let's go to the next slide.
Yes, you are correct, Jonathan. Thank you so much for your presentation. Now I'd like to open the floor for questions. So if you have any questions, please type them in the Q&A box in the lower right-hand corner of your screen, and I'll make sure to get to them for Jonathan. I'll start out with one. So Sessions has made kind of negative statements about marijuana, and it has been telling prosecutors that they should go for maximum sentences instead of minimum. And I was just wondering, what is your opinion? How seriously should we take his comments?
Yeah, so I think if you are someone who's in a state and you are promoting yourselves, holding yourself out to be a legal drug operation, I should take my own advice, a state-authorized drug operation, a grower, but you're diverting product to a drug dealer, an illegal drug dealer, or you are a patient and you are diverting supply to a minor, or you are doing one of these things that Sessions and DOJ and the Cole Memo have laid out in their enforcement priorities, then I think you have reason to worry. Look, never say never. I think that there are some protections in place right now for people who are squarely within the confines of what their states have authorized. And so never say never. I'm not saying that Sessions and DOJ won't go after them, but what I think Sessions means by that is, don't get, and this is my paraphrasing what I think his position is, don't get caught up in the hype. Marijuana is still illegal, and yeah, we know that the states have authorized it, but we don't really put a lot of stock in that, and you better be careful before you do anything other than what the state has explicitly authorized. And by the way, I will tell you that does not just extend to people in the space. That extends to people like me. Sessions just the other day issued a pretty stern warning to attorneys saying, basically threatening them, not wanting to advise people in the space, saying you need to be really careful when you advise people. And look, like everybody else in the space who I think is worth their salt, you're going to see disclaimers on my firm's webpage, on our cannabis law webpage, and I think you try to protect yourself. There's no guaranteeing that people won't use your advice for ill, but we are obviously very careful to tell our clients that this is obviously geared toward state-authorized operations, and to the extent you do anything illegal, you're on your own, and we are in no way endorsing or authorizing that. So, Catherine, long answer to your question is, I think we need to take it seriously, but if you are operating within the confines of a state program, then I think currently, at least until Rohrabacher Blumenauer expires, if not renewed, you're okay, but have your head on a swivel.
Oh, thank you so much for your answer, Jonathan. So we have questions coming in. So I have a question here from Steve, and he asks, what are your thoughts on Sessions going after MRBs and or their owners for money laundering or tax evasion instead of drug trafficking? Yeah.
Sorry, so I think so Steve, thanks for the question. I think MRBs is marijuana-related businesses, if I'm not correct. Could submit a quick follow-up. But I just actually looked at this issue for a client, and ancillary service providers, people who are designing greenhouses, people that are installing irrigation equipment, people that are providing accounting services or tax services. Again, I think the relevant inquiry is, are you helping people shelter their income in a way that is not on the up and up? Are you doing anything that's out of the ordinary to evade tax laws or reporting obligations? For straight up ancillary service providers, if you, again, are providing services to a business in your state and your state has authorized activities for the services that you're providing, so, irrigation equipment or design services or accounting services, then I think, I'm not going to say Sessions and DOJ won't come after you, but I think you're going to be higher up on the tree than some of the low-hanging fruit of an accountant or a tax consultant or a tax attorney who says, hey, we should shelter your income this way, and we should move this from one area to another so it looks like you're not making as much money, and those sorts of things. That's not to say that there aren't what are generally viewed to be compliant ways of doing business. A lot of people in this space set up management companies, and have loans going between the management company and the dispensary or the grow operation, and taking the economics and pulling it out of the dispensary and putting it in the management company, and investors investing in the management company. I'm not suggesting that any of this is legal or illegal. I guess what I'm saying is there are generally recognized practices in the space, and then there are practices that are very edgy and operate on the edge of a steep cliff. And so I think that in terms of thinking about where Sessions and DOJ are going to go, it's going after the low-hanging fruit. It's people that have a website that aggressively market in ways that if the DOJ were reading it, it would be very easy for them to determine that you're not providing a legitimate service, or you're helping a client to take what is otherwise an authorized operation and turn it into an illegal operation.
Thank you so much for your answer, and thank you, Steve, for the question. We have a question here as well. Thank you for explaining the acronym. We have a question here from Randy, and he says, can you address whether hemp products are illegal across states? Many advocates say there is a loophole in the hemp law that allows for this, but FDA and DOJ seem to disagree.
Yeah, so the hemp issue, I'm sorry, this is going to be a disappointing answer. In my view, I think it's an unsettled one. So a lot of people talk about industrial hemp, and that they define that as hemp with lower than 0.3% THC, which THC is one of the many cannabinoids from the marijuana plant. THC is also what produces the quote-unquote euphoric effect of marijuana, whereas CBD or cannabidiol is more commonly associated with the medicinal properties, although some of my friends in the space who might be on this would disagree with me that the medicinal are really more from THC, but in any event, not to get too far afield. So hemp and industrial hemp, and whether CBD oil that is derived from hemp is legal, I think is a very unsettled question. I will answer a slightly different question, and I don't know, Randy, if this gets to what you're asking, but there's a lot of people like to think that CBD oil is legal. Legal as in, you can sell it and you buy it wherever you want, but I and others are of the viewpoint, not that it should be this way, but the way that it is that DEA, the Drug Enforcement Administration, still views CBD oil to be a Schedule I product and thus federally illegal. Now, CBD oil sales in states that have legal marijuana, authorized marijuana regimes, if you're selling it intra-state, just within that state, do I think there's less risk? Maybe, but in my view, a lot of these CBD oils are sold on the internet and are sold interstate. And so I think anything that has a trace of THC could be viewed as federally illegal. So, before I say that hemp is clearly illegal or legal, I would say that the views that the current administration is taking and the uncertainty, there was some talk, a couple years ago in the Farm Bill, in the 2014 Farm Bill, about industrial hemp and making it clear that hemp is legal and that it's different from CBD and CBD oil derived from marijuana. I'm not there yet, and I don't think there's authoritative enough information to suggest that it's legal broadly.
Thank you so much for your answer. So we're kind of coming up on the legalization in California, but since it or the implementation, of the legalization, and before we get there, dispensaries have been selling recreationally to people without medical recommendations. That has definitely been happening. And do you believe that's where, the federal enforcement is probably going to happen for California and for future states?
Yeah, so I think it's an interesting question. And by the way, California is supposed to roll out as of January 1st. Not to besmirch the efforts of those who are rolling out, but I've heard that complying with the regulations and getting up and running, that a vast portion of the industry is not ready in California. I think the way that the state has approached regulation for medical and rec has been confusing to industry. And the other thing about California that's tricky is that the localities also have their own regulations. Marijuana Business Daily put out a chart recently that shows it's like a check mark box of different things that are allowed in different cities and towns. I don't know that I see the feds necessarily operating in what I call the California gray area, but I will tell you I'm aware of some businesses that had been operating in California for years and years and years and found themselves in trouble, not with the feds, but with state regulators. So, I guess I'm not as concerned with the feds in California as I am with the state and the localities. Now, again, if you're blatantly violating federal law and you're selling recreational when you're really only supposed to be selling med, then absolutely, I think the feds can come after you. But my concern on California is more compliance with the regs and operating within the confines of the state requirements and the local requirements. I just want to address one thing if we don't have any other questions, which is I mentioned CBD oil. The important thing to understand about CBD oil, a lot of people sell this on the internet. You might have seen that Target actually that Target, the national chain retailer Target, had on their website for a brief period of time CBD oil. Now they took it off after a few days. CBD oil, again, I am of the viewpoint, and others agree with me. I think it's pretty well established that DEA considers it to be Schedule 1, but a couple of things that could change that. There are some pending drug applications before the FDA for a CBD drug product. GW Pharmaceuticals has some clinical trials for rare diseases and disorders, seizure disorders. If FDA approves that application next year, I think the decision's expected out next year, DEA would have to come out with a descheduling decision. There's a great article in Law 360 that a friend of mine from another firm wrote this morning, if you haven't seen it already, which discusses that. But CBD oil, claiming that it does certain things and it hasn't been studied for those things, and making drug and disease claims, you will find yourself into hot water in hot water with FDA pretty quickly. And my justification for saying that is, just a few weeks ago, FDA issued warning letters to firms that were selling CBD oil and making medical claims, disease claims, drug claims. So, I've said that CBD is it's unsettled at best regulatory status, but just know if you are selling CBD oil and you are making claims, you need to be very, very careful, because regulators have that directly in their sights.
That's very interesting. Thank you, Jonathan. We have a question here from Tabitha, and she asks, she states, Louisiana is unique in that the regulatory agency is the Department of Agriculture and Forestry on the production side, and the Board of Pharmacy is the is the regulatory agency for the dispensaries, and the producers are 2 universities. Do you think, Jonathan, that the universities or any of the dispensaries are at risk of federal enforcement?
Yeah, so that's an interesting question, and I know a little bit about Louisiana's program and some of the interesting divisions there. And Tabitha, thanks for raising that for everyone's benefit, because I think it's important, again, for people to understand how different these programs are, and it's not just regulated by one entity in the state. For a university that receives federal funding or that's part of federal programs, if I were the university or advising the university, I would look very closely at what stipulations there are on that funding. I can tell you in the healthcare space, for nursing facilities or hospitals that receive federal funding, some have taken a pretty conservative view, and I think rightly so, that there are certain things, in order to get federal funds, like Medicare dollars, they need to be in compliance with all federal, state, and local laws. Now, do I think that the DOJ is going to go after these healthcare facilities or these universities who are involved or dispensing or are allowing people access these drugs? I don't know. I haven't seen that yet, but I do think it raises a very interesting question for a federally funded university, what their positions are, and also ensuring safety of their students and all those sorts of things. There's a lot of issues there, and so yeah, I don't know what the exposure is for the university, but I think it's worth exploring, and there is potential exposure. I guess that's my short answer.
Well, thank you so much. I think this will be our last question, and feel free. It's gonna pretty much hit the nail on the head here. But what do you expect that Attorney General Jeff Sessions will scrap the 2013 memo? If you feel comfortable answering.
Yeah, I might have said yes a few weeks ago, but I think that Sessions is seeing that his task force said no, keep the Cole memo in place, and he's like, all right, I see your refusal, and I up you that I'm going to use that memo, and I'm going to use it as my justification for interfering with the states, or going after activity in the states that I deem to be under the purview of the Fed. So, yeah, I think that Sessions can do what he wants with or in spite of the Cole memo. I don't know. I almost, it's not that I don't think it matters, but I think that you've seen that Sessions is willing to manipulate the Cole memo for his own purposes, for the DOJ's purposes, for maybe the administration's purposes. So, yeah, I don't know that I have a prediction on that, but again, I'm not so sure that the Cole memo really matters. I will say if he wants to revoke it, he's taken an important first step, which is the action that he took a couple weeks ago to say that we're not going to be bound by these policy memos anymore. So maybe he's setting up for it. Again, not sure it matters one way or the other.
Thank you so much, Jonathan. That's all the time we have for questions today. If you have any additional questions for Jonathan, please feel free to reach out. I'll let Jonathan take it away.
Yeah, so I have on my next slide, if it's, there it is, my contact information. So if you're not already connected with me on LinkedIn or following me on Twitter, I would encourage you to do that. I post quite a bit of material, especially in the cannabis space. My firm also has a blog called The Regulatory Roundup, and feel free to get in touch with me. Happy to answer any questions offline. And if you will be at the Canna East Summit in Orlando in January, I look forward to meeting you there. These are a list of all of our offices, just to show you where we are, down from Miami all the way up to Boston and out to Chicago. So have a lot of overlap in the states where there are state-authorized marijuana regimes.
And thank you all for tuning in today and for being so patient. I have just dropped the Cole Memo webinar PowerPoint into the handout section of GoToWebinar. You'll see that under the Q&A section. So feel free to download that and take a look at all of Jonathan's great research. And feel free to check out our Canna East Compliance Summit. So that is all for us today. I just want to say thank you all for joining our webinar. As a reminder, you will receive an email with a recording of this webinar within 24 hours. Before you go, make sure to sign up for Canna East Compliance Summit. It's going to be in Orlando, Florida, and we're really looking forward to having Jonathan there. For more information and to register, go to infocastinc.com/event and look up our Cannabis Summit. And thanks again to Jonathan and everyone. I hope you guys have a great day, and we'll see you next time.